I've been reading again, so that means it's time for another video. This time we're discussing foundational documents. The primary book we're discussing is The Five Types of Legal Argument, 3rd edition by Wilson Huhn. And primarily we're looking at chapter 16 and beyond. Also like to point out that the foundational documents as examples for what we're going to discuss, which is a bit beyond what Huhn was discussing, were all what I'm considering foundational documents. And then naturally, we're going to talk about how armies fit into the picture. So on page 149, foundational or privileged factor theories assert that only certain kinds of arguments are valid. As a result, they deny the legitimacy of other kinds of arguments. And while Huhn's correct to point out that maybe in a courtroom this isn't such a great idea, this does have a much wider impact on the state. So the Five Types of Legal Arguments, a great book to talk about interpretive legal devices as used in a courtroom. But Huhn, of course, focuses narrowly on the pluralist conception. And I think he does not do justice in chapter 16 to the wider meanings of a foundational document. And of course, won't really get into the whole Scalia side of things because I haven't read anything, or I'm in the process of reading that. But Five Types of Legal Argument is really lacking in its descriptions on foundational documents like the Constitution. So I'm going to offer up a wider, more encompassing definition of foundational cross-type arguments. They are a military contested point of determination of principles of the law. And of course, pluralists such as Huhn naturally view the law as indeterminate. Well, it's sometimes determinations are made and armies are involved in that determination. And we're going to discuss that more later. But just keep in mind that all of these documents that I'm pointing to examples have armies attached to them in some way. And of course, I'm not going to get too down in the weeds with any of these. I'm listing a few principles that were sort of at stake from different sides in the contest. But just pay attention to the different kinds of wars, like the Magna Carta, because there's a lot of arcane legalese in the Magna Carta. That's very hard for us to make out and understand in modern terms. But the way we understand this, the way we can understand it best would be to view these as sort of interpretive devices, special interpretive devices. And all of these documents have, even if they are, even the more clear ones, such as the American Constitution, will have these special interpretive devices. And then you can sort of see what the actual issue is. It's usually more of a military issue. So like in the First Barons War, we're talking about the issue of distraint, which is a wider custom of the time. And then we have, of course, the rise of Parliament. And I suggest you see my video on the development of legislative power on a somewhat related subject to this. But we'll move on to the Grand Remonstrance. And of course, for those of you all who don't know, the Grand Remonstrance is sort of the defining document of the English Civil War. It's what if the Grand Remonstrance hadn't happened, Oliver Cromwell probably would have been an American. So this is sort of that's the level of power of that document as a foundational argument. It kept Oliver Cromwell in England, and then basically because he was there, he was able to, through his military genius, have the only written constitution in English history was because of Oliver Cromwell. And the New Model Army, and there's the Putney debates, fascinating subject. I suggest you look up on it. We're not going to talk about that here. But then I like to point out with the Grand Remonstrance, though, it seems like despite the foundational cross-type argument of the Grand Remonstrance, the structural problems existed with both Charles I and Cromwell. So it was a wider issue that even the government didn't seem to be able to fix with the Grand Remonstrance. So naturally, if you're an American, you're probably seeing where this is going. And we get to the American Constitution. There's 7 or 8 principles that have been identified and discussed at great length in many publications that are readily available at all sorts of different levels. And so I again suggest you look up and read some of those, but that's not really what we're about. All we're really interested in for this purpose of this presentation is the fact that we're considering the Constitution as sort of like the most put together that you might expect one of these foundational cross-type arguments to be, yet it still has these special interpretive devices, and we'll get to that in the following slides. All right, all of these documents that I've discussed previously can say to be following international controversy. That includes the Grand Remonstrance because the first, at the beginning is usually called the Crisis of Three Kingdoms. So, and you had the Scots and the Irish involved in various battles in the, even though this is maybe sort of an internal UK thing, it's still an international controversy. And I guess that's sort of pointing to these wider above government kind of things that seem to be at play when you talk about these foundational arguments. Um, and then notice because you have these wider issues at play that seem to be sometimes exceed the government or the power of the government, the only way the government can hope to have any sort of effect on that is to mobilize an army, or if non-government entities to mobilize an army to move those principles around, and they'll make no bones about it that that's exactly what they're about. So keep that in mind. So some of the examples of these arcane and esoteric provisions or interpretive devices that you see talk about fish weirs in the Magna Carta. God knows what that was about. And you have ecclesiastical tyranny in the Grand Remonstrance. Again, several issues, undoubtedly, multiple principles at play, but the big picture, the foundational argument is about the ecclesiastical tyranny, the big image, the almost the cliche that doesn't quite rise to the level of just below the level of being legalese, but it's there. And so, like, then you have examples that are perhaps legalese, but maybe they're just over the line, and maybe that makes them very difficult because it's more like a cliche. And I think the Third Amendment, to some degree, in the Constitution, sort of fits that bill. It's Third Amendment has been pointed out by some observers as spent more time in the press than it has in the courtroom, and so that's sort of you see the crossover that we're talking about here, where the foundational argument is sort of where you build up to the point where you start talking about the interpretive devices of law, but we're not there yet. It's just a foundational argument. So what goes into these foundational arguments? At some indeterminate and irrational point, pretty much anyone will resort to a foundational cross-type argument. And then enough people agree on that. Well, now you're talking about ideas of popular sovereignty. You're mobilizing armies, and then the only way you can maybe deal with that mob, whatever, is you have to have some sort of mechanism, either a governmental or a super governmental. I've sort of discussed those previously, but a lot of times these arguments will be captured in Senate campaigns. Why are the midterms so important in America? Well, because you maybe pick up and police up some of these foundational arguments that enter into the sphere, the cliche, political cliche, and that's how they move from cliche into a foundational argument as a platform that the politicians have, and then that platform might result in changes or amendments to the original text, the original text of the law, which will then perhaps need a new interpretation out of the courts because of the way the law changed. And this is sort of this whole process of how these things change. It starts with these foundational arguments, and it's best for the government. Government works best if it captures that through the Senate, the Parliament, through multiple elections, through multiple jurisdictions at multiple times, and that's how we do it in America. It seems to be what works the best. But you also got to keep in mind, in some of these places like the UK, they seem to be relying on these super governmental structures, like whether you want to call it tradition, custom, or geographical determinism. That there seems to be something beyond just the government idea behind these arguments. So because the foundational cross-type argument is so essential to anybody and everybody can, you have to have a belief to exist, basically. So that sort of feeds into this idea of political legitimacy. And then you have the courts, I mean, in the vast majority of what are considered common cases, like, uh, common assault case or something like that. I mean, basically you have somebody acting with foundational uh, cross type argument. They deserve to have the bread, not you. And for whatever reason, moral reason or not moral reason they want to give. And then that would end up in court to mediate between who has the legitimate, who's resting on the legitimate lawful foundation and who is acting with an illegitimate foundational cross type argument. And so we've already sort of discussed this other bit about this connecting the cliches to greater law, and it happens every day in most courtrooms. All right, I'm going to do my best to wrap this up as succinctly as possible. But my biggest issue with Huhn and his book, as much as I love all the chapters leading up to chapter 16, the fact he somehow does not allow American law to stay just American law. He does not explain why, he just sort of assumes and goes through the motion and assumes that, okay, we're all talking about the Constitution. We'd never talk about anything else. But he's tacitly allowing these other, maybe some British law or some weird parliamentary thing they do in England to be introduced into the American judicial system. And that's the issue with his definition of a foundational cross-type argument. He does not exclude all other jurisprudence and law from American law practice. And to me, that it seems like a small oversight, but it's a big thing. And obviously, it's very important because sometimes what is not said is more important than what is said. And again, this goes back to these ideas of legitimacy. So he's failing to define American legitimacy, and that is a very serious problem if you think about it. Maybe he doesn't view uh, American law as uh, legitimate, and I think that's a real issue if you're talking about a lawyer in an American court of law. So the quick sum up: foundational cross-type arguments are an essential component of Republican discourse. However, foundational cross-type arguments engagement with the realm of law and jurisprudence is limited to foundational documents like the American Constitution or some of the other ones we've discussed. Now, all foundational cross-type arguments have I'm calling special interpretive devices that are fodder for the media, and they have their primary force as political cliches. Third Amendment. And then obviously, because foundational cross-type arguments are mostly of the public sphere, that's why they serve to sort of mobilize armies, precisely because they lack any power within the realm of law. Um, so if you made it this far, congratulations. No prize, but thank you.